absolute and qualified immunity. Remember, we spoke about those child support agencies, those child welfare agency employees coming about, acting as the one with the information when they create a cloud of legality within the family courts or the county courts or state courts or the agencies. This is the reason why they can come in front of your door confidently, talk a bunch of trash, and do things arbitrarily. They don't know the details, but someone within the hierarchy of their corporation have conditioned them to be comfortable because they know this exists. You must be aware of it also. You must not be blind to these things. There is so much that's going on that people are not aware of. Plaintiffs have stated claims that defendant violated their procedural due. Look at that. Plaintiffs have stated claims that defendant violated their procedural due process rights. On count 3, substantive due process right. Count 2. Again, on Patreon, we go over clearly the difference between these two. In this video, we've given summarized examples here and there. And their First Amendment rights to intimate association, count 1, 2, 5. Plaintiffs have also stated claims that defendant Miracle and Caprio have supervisory liability under Section 1983, count 4. Defendants argue that they have absolute and qualified immunity from plaintiff's claim. Interesting. They go on to say that the Third Circuit has held that child case workers, listen to this, child case workers are entitled, quote, are entitled to absolute immunity for their actions in petitioning and in formulating and making recommendations. So one of the ways you can bring criminal charges, because they do criminally charge parents for suppositions of child-related matters. One of the ways you can do that, as we go over in Patreon, is you can, beautiful people, welcome back. Let's speak of parents and their children when it comes to circumstances that children are taken away from their parents. There are a plethora of reasons where any representatives of some entity will have as to why they say they are taking those young ones away from the parents. We're not looking at that plethora of reasons. We're looking at two very simple things: the substantive due process and the procedural due process involved. There are two types of due process, and those are the two types that we just mentioned. A whole separate video on that is already done on Patreon, but on YouTube, we're gonna go over other examples relating to it. But know that you need a foreknowledge of the different types of due process for most of this to make sense. Because what we're going to entertain here is we're going to show you the importance of what's constitutional and the fact that this important constitutional provision is not being followed when children are taken away from parents. And then we're going to show the intricacies when it comes to the procedural aspect of it, which is a form of due process, whereby those taking those children are actually afforded immunity. A lot of people know about qualified immunity, which is applicable to acting judges, applicable to municipal employees who are armed. And qualified immunity has its origin in the 11th Amendment, which we've already created 2 separate videos here on YouTube dedicated to that. So I implore you to watch that for you to get the foundational knowledge on the origin of sovereign immunity as it refers to the Constitution, albeit anything after 10th Amendment is not Bill of Rights, but is in fact specific to the representatives and the enclaves of the United States. But then that's just qualified immunity. But you also know that other types of immunities branch out of qualified immunities, like prosecutorial immunity. And then other representatives of municipalities and its agencies can sharecrop prosecutorial immunities if they're. Now, these founding documents called constitutions exist also on a state level, and each state have their own respective constitution. So whatever it is we're mentioning here on a United States level, know that the same principle, and in many cases the exact verbiage, word for word, clause for clause, exists on a state level. When it comes to parents and children, specifically the children being taken away physically from the parent, there's this thing called the First Amendment. Usually within these things called the Bill of Rights, First 10 Amendment on the United States level, one article or one specific bill can have about 6 or 7 clauses or 3 or 4 clauses, and each of those clauses will represent specific rights. Most people usually combine 2 specific clauses that have about 3 different rights or 2 different rights and categorize it as one. That is another for the subtle intricacies. This thing called the First Amendment speaks about several things. One of those things it speaks of is right of association. The right of association can be used in court cases where attorneys are being compelled upon you. That is, if you don't know how to recuse an acting judge, either by right or by showing cause. That is, if you don't know how to put, if it's a civil case, a preponderance, if it's a criminal evidence beyond a reasonable doubt. Or you can use the lower standards like probable cause, which is a standard or a weight of evidence. There's probable cause, clear and convincing, preponderance of evidence, etc., etc. The right of association can be used for court-related matters if you can show through preponderance of evidence or evidence beyond a reasonable doubt that there's conflict of interest if that attorney was put upon you. The right of association can be invoked when it comes to your properties, tangible or intangible. In this specific instance of a child and a parent, the right of association can be invoked. Freedom of religion, speech, and press, right of petition. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievance. So where in this exact portion that we just read, where does it even mention anything about right of association? Believe it or not, we just did. Many people who speak about having right speak of it from a prima facie aspect, meaning look, it's right there on a pen and paper. They don't see beyond what that word substantive truly means. This is where you need to see the subtleties for you to know what your rights are. Let's read it again. Congress shall make no law respecting an establishment of religion. That is one substantive right. That is one substantive due process mentioned. But listen to this closely. Or prohibiting the free exercise thereof. This second clause, where it says Congress shall not make any law prohibiting the free exercise thereof. The inability of the Congress to make a law to stop you from respecting a religion has its root in your ability to associate with others. If you notice very carefully, the second clause is not limited or specific to just religion. It makes reference to the first clause, so long as it's the benefit of the public. Do you not know that these caseworkers that work for these private corporations, like we've shown on Patreon, do you not know that they are using the right to petition right here? Congress shall make no law prohibiting the right of the people peaceably to assemble and to petition the government for redress of grievance. This last clause of the right to redress of grievance and petition, right of petition, is exactly what they're using against you and your children. They are flipping the table so quick. Complete 56-minute video is on the Patreon page. Take care and best of luck.